Hello, I'm David Roger, General Counsel for Las Vegas Police Protective Association. A detective asked whether police are required to get a search warrant before going and seizing a person's property, which is being held at the Clark County Detention Center or a jail facility. And the answer is no, a hard no since 1974. Police are not required to go get a search warrant to seize property that is lawfully in the police department's possession at the Clark County Detention Center or any jail facility. And so let's talk about a couple of cases. In 1974, the U.S. Supreme Court addressed this issue in U.S. v. Edwards. And in that case, Edwards was arrested for attempted burglary of a post office. Edwards tried to pry open a window, and crime scene analysts saw pry marks, saw that paint scrapings from the wooden frame of the window were scattered just below the window. And so police went back to the jail facility and saw that the clothes that Edwards was wearing at the time had paint chips on them. So they seized his clothes and used that to compare the paint chips and eventually convict him. And Edwards said, hey, they took my property. And the U.S. Supreme Court quickly rejected that argument that Edwards made, that they needed a search warrant to go get his property. And so here's what the United States Supreme Court said in 1974. When it became apparent that the articles of clothing were evidence of the crime for which Edwards was being held, the police were entitled to take, examine, and preserve them for use as evidence, just as they are normally permitted to seize evidence of crime when it is lawfully encountered. Indeed, it is difficult to perceive what is unreasonable about the police examining and holding as evidence those personal effects of the accused that they already have in their lawful custody as a result of the lawful arrest. And then they concluded their opinion by stating this: while the legal arrest of a person should not destroy the privacy of his premises, his home, it does, for at least a reasonable time and to a reasonable extent, take his own privacy out of the realm of protection from police interest in weapons, means of escape, and evidence. And so really what they're saying is twofold. The Fourth Amendment prohibits unreasonable searches and seizures, and they felt that when a person's property is already in custody of the police, it's reasonable to go and seize that as evidence. And secondly, as commentators would say later, an inmate does not have an expectation of privacy while housed at jail. And so in 1978, 4 years later, the Ninth Circuit Court of Appeals, and remember that Nevada is in the Ninth Circuit, and so with respect to constitutional issues, the Ninth Circuit controls Nevada. In that particular case, an individual or individuals were arrested for bank robbery. Witnesses described the clothing, and when the individuals were arrested, the police went back to the jail and seized their clothing, which was incriminating evidence. And so this is United States versus Oaxaca, Oaxaca, 509 F. 2nd, 518, and once again, a 1978 case. And in that case, the Ninth Circuit Court of Appeals concluded that police did not need a search warrant to go back to the jail and seize the property. And they said both defendants and their shoes remain in lawful custody until the time when the shoes were taken for use as evidence. To require a warrant under these circumstances would be to require useless and meaningless formality. So I don't know if there is a written or unwritten policy at the jail which is requiring detectives to go get a search warrant to seize property, but if there is, stop. It is a useless waste of manpower to require detectives to go get a search warrant when police are already in lawful custody of property. Thank you for listening to these videos. I hear from officers that they're receiving training that they believe is questionable. Contact me. I'm not a shoot from the hip person. I will give you case law, and I will tell you what the lawful case law is, the controlling case law in our jurisdiction is. Please contact me, droger@lvppa.com. Give me a call. Shoot me a text, whatever you need to, but please contact me if you have legal issues. Thank you.
111, 110.